Cameras in the back of the room are because we are being live streamed this afternoon. So if you miss an important point, you can always go back and watch it later, which is great. And you may already have signed the CLE, which is in the back of the room. If you haven't, I would urge you to do that if you need CLE credit before you leave today. And one other housekeeping announcement, we have index cards that are in the back and we have staff that are holding them. If you need an index card, we're using those to get questions because we always have a lot in this session, so we want to make sure everybody's questions gets answered. So raise your hand if you need an index card if you didn't pick one up, and our staff will come around and let you have one of those. And with that, I think we're going to go ahead and get started. So good afternoon, everybody. And welcome to our session where we're going to give you an overview of recent Supreme Court cases and their state impact. This afternoon, we are so fortunate to host Amy Howe, who is the editor and a reporter for SCOTUS blog, which you all may be familiar with, until 2016, where she continues to serve as an independent contractor and reporter. She primarily writes for her own blog now, Howe on the Court. Urge you to take a look at that as well. Before turning to full-time blogging, she served as counsel in over 24 merits cases at the Supreme Court and argued 2 cases there as well. She has co-taught Supreme Court litigation at Stanford Law School and as an adjunct professor at American University's Washington College of Law, which is my alma mater law school. And she's also co-taught a similar class at Harvard Law School. So she's very knowledgeable on all things Supreme Court. She is also taught at Vanderbilt. She's a graduate of the University of North Carolina at Chapel Hill, holds a master's degree in Arab Studies and a law degree from Georgetown University. So as I mentioned, you guys have index cards. We urge you to write your questions down. We're only going to take written questions because there's so many of you here in the room. And you can pass your cards to the end of your row when it's time for Q&A, and we'll make sure that they get responded to. So now let's give Amy a big welcome, and we'll get to the meat of our session. So the first case we're going to talk about today is a case called Grants Pass versus Johnson, which took up the issue of homelessness and whether a locality's anti-camping ordinance violated the 8th Amendment's prohibition on cruel and unusual punishment. So tell us about the facts of that case, Amy, and where the court landed on this issue.
So Grants Pass is a city in southwestern Oregon, a city of about 38,000 people, and on any given night in Grants Pass there are about 600 people experiencing homelessness. A couple of years ago, Grants Pass passed this public camping ban, and the way they defined public camping, it prohibited people who are unhoused from using blankets, pillows, and cardboard for protection from the elements. So a couple of people experiencing homelessness went to court, federal court, challenging the public camping ban, arguing that it violated the 8th Amendment's ban on cruel and unusual punishment. And by a vote of 6-3, the Supreme Court upheld the public camping ban. It was a decision by Justice Neil Gorsuch. And first, he said, the 8th Amendment, we usually think of the 8th Amendment as something that governs the kind or method of punishment that governments can impose after someone violates a criminal law, that we don't usually think of the 8th Amendment as something that governs whether or not a government can make a particular kind of behavior criminal in the first place. So that wasn't really an issue in the case as much as the Supreme Court in 1962, in a case called Robinson versus California, held that a California law that made it unconstitutional to be addicted to narcotics violated the ban on cruel and unusual punishment. And the challengers in this case argued that the public camping ban in Grants Pass was just like Robinson because it effectively criminalized the act of being homeless in Grants Pass. So Gorsuch said, no, these are different. He said, first of all, Robinson really was kind of unprecedented. The parties in Robinson didn't really make this 8th Amendment argument, and we didn't really extend Robinson at all after Robinson in 1962. But in any event, he said the two are different because Robinson was about status. It was the California law at issue in that case made it a crime to be addicted to narcotics, whereas the public camping ban doesn't make it a crime to be homeless in Grants Pass. He said it makes it a crime to camp in public, he said, and so it applies to everyone, whether you're unhoused or not. He rejected the argument that the public camping ban would effectively criminalize status because some people who are unhoused don't really have any choice other than to be unhoused. He said, we already rejected that very same argument in a case called Powell versus California involving alcoholism. And in the end, he said, homelessness is a complex problem, but it's not a problem for federal judges to solve. It's a problem for the democratic process. He said, nothing in the Eighth Amendment gives federal judges the power to solve the problem. It doesn't give us any guidance on how to answer questions like what's adequate shelter or when someone has somewhere else to go.
Thanks, Amy. And what about the dissent in this case? Did anything surprise you about that? And can you tell us a little bit about what Justice Sotomayor had to say about that majority ruling? So
Justice Sotomayor wrote a dissent on behalf of herself and the two other liberal justices, Justice Kagan and Justice Jackson. That's going to be kind of a common theme you're going to hear me talking about in a couple of the cases that we're going to talk about today. And she just started from a very different premise. From her standpoint, the idea that the public camping ban doesn't criminalize status is sort of angels dancing on the head of a pin. She said, of course, it criminalizes status, it criminalizes being homeless in Grants Pass. And she faults the majority for really focusing on the problems that local governments create and that experience in responding to homelessness, and not looking at the causes of homelessness and the experiences of people who are unhoused. And I guess when you're talking about sort of surprise, I was watching Justice Kagan in her speech at the Ninth Circuit Judicial Conference a couple of weeks ago, and one of the things she mentioned, talking about retired Justice Anthony Kennedy, who was the circuit justice for the Ninth Circuit for a long time, and she mentioned that when he was on the Supreme Court, he was what she called the civility enforcer, that if someone had sort of language in one of their opinions that he thought sort of crossed the line, he would call them up or go to their chambers or send them an email and say, maybe you might want to tone this down a little bit. And Justice Sotomayor's tone in her dissent is pretty strong. She sort of closes with the line, she said, I hope someday in the near future, the court will play its role in safeguarding constitutional liberties for the most vulnerable among us, but the court today abdicates that role.
So, to conclude our conversation on this particular case, what do you think this ruling means for states and localities who may want to continue or may legislate in this area in the future?
So the court, I think this decision really effectively closes the door on an Eighth Amendment challenge to these kinds of public camping bans, but the court points out that somewhere like Grants Pass may be limited by state laws that are in place already, or that states could pass that could limit what local governments can do to address public camping, to regulate public camping. So the Oregon law, just to give you an example, provides that any law that regulates the act of sitting, lying, sleeping, or keeping warm must be objectively reasonable as to the time, place, or manner with regard to persons experiencing homelessness. So, again, it might sort of close the door on an Eighth Amendment challenge, but there may be other limits imposed elsewhere.
And do you think there could be another case in this line that might come before the court going forward?
So, in addition to the Oregon law, Justice Gorsuch's opinion mentioned that there may be other defenses that may be available to people who are unhoused, who run afoul of these ordinances, that you could, even if it's not cruel and unusual punishment generally, if you are fined or arrested under one of these ordinances, you could raise a necessity defense. You could say, no, I personally have nowhere else to go. There could be due process arguments, either the idea that the city is enforcing these selectively, that you didn't have fair notice, I think Justice Sotomayor's opinion says that there may be an excessive fines defense, or excessive fines challenge under the Eighth Amendment. So, all of these issues, either in this case or in some other case, potentially could bubble back up to the Supreme Court. I mean, depending on how the laws are drafted and how they're enforced, they could be pretty fact specific. So it's not clear, whether they'd bubble back up to the Supreme Court.
Okay, lots for us to think about with respect to these types of ordinances. Let's move on to another case called United States versus Rahimi, which addresses the federal law prohibiting the possession of firearms by people who are subject to a domestic violence restraining order, and whether that federal law violates the Second Amendment. This case had an interesting procedural history, so tell us about how this case made its way to the Supreme Court.
Yeah, it's kind of not the usual path to the Supreme Court. I will say that the United States is the one who brought this case to the Supreme Court, and it's hard to imagine a case that the United States could bring to the Supreme Court that would be a stronger set of facts for this challenge, perhaps a less sympathetic defendant. So the defendant in this case is a man named Zaki Rahimi, and in 2019 he became subject to a domestic violence restraining order in Texas after an incident in which he was arguing with his girlfriend, dragged her across a parking lot, tried to shove her into his car, and in the process of shoving her into his car, she hit her head on the dashboard, and then he fired a gun. It's not clear whether he was firing the gun at her or at a bystander in the parking lot. So the state court enters an order in which it finds that he had committed family violence and that he remained a credible threat to both his girlfriend and to their child. So sort of fast forward a little ways, and he is the a suspect in a series of shootings around the Dallas, Texas area. So the police get a warrant to search his residence, and they find a pistol and a rifle and ammunition. So he is then charged with violating this federal law that makes it a crime to have a gun if you are the subject of a domestic violence restraining order. And at the time, the penalty for violating this statute was 10 years. I think it has since been increased to 15 years. So in the district court, he argues that this law violates his Second Amendment right to have a gun. And the district court, again, this is before the 2022 decision in New York State Rifle and Pistol Association versus Bruin, rejects his request. So he pleads guilty, he appeals, makes the Second Amendment argument on appeal, and initially the panel of the Fifth Circuit turns him down. And then the Supreme Court in 2022 issues its decision in Bruin. And in Bruin, the Supreme Court strikes down New York's concealed carry regime. And it says that, when you were looking at whether or not modern gun restrictions violate the Second Amendment, you're going to look at whether or not there is a sort of a history and tradition of such regulations in early U.S. history. So the Fifth Circuit says, let's have more briefing on this issue in light of the decision in Bruin, and it ultimately rules for Rahimi. So the federal government takes the case to the Supreme Court, which agrees to weigh in and reverses the Fifth Circuit and rules for the government. So after Bruin, there was a lot of confusion about how lower courts should apply this history and tradition test. How similar the modern laws have to be to these historical regulations to pass the history and tradition test. And so the Rahimi decision was supposed to clarify what the court meant in Bruin. It was an 8-1 decision. The sort of interesting part about this 8-1 decision that's supposed to clarify Bruin is that the decision was written by Chief Justice John Roberts. The lone dissenter was Clarence Thomas, who wrote Bruin. So there's a question of how much it was clarifying in the first place, or how much it was perhaps forging a little bit of new ground. But the Chief Justice, in his opinion, says, when we're talking about the history and tradition test, we're not talking about law preserved in amber. So, this is one of these phrases I think we're going to hear a lot over the next couple of years. You don't need a dead ringer for the modern regulation in the past or a historical twin. He said, after all, when we're talking about the Second Amendment, the Second Amendment doesn't only protect the weapons that were in existence at the time of the founding, because otherwise the only weapons you'd have a right to have would be muskets or sabers. So similarly, it can't be that the only gun restrictions that are going to be constitutional are the exact same ones that were in existence at the time of the founding.
So the court also took a position on what they called analogous principles to the Second Amendment. Can you explain for our folks here what that means?
Yeah, so what he said is, you're talking about whether or not there's a history and tradition. The question is really whether or not the modern regulation is relevantly similar to historical laws, and you look in particular at why and how they place a burden on the right to bear arms. And so, in particular, Roberts said, if laws in the founding era regulated guns to address a specific problem, a modern regulation that places similar restrictions for similar reasons are going to be more likely to pass muster. And so in this case, the Chief Justice looked at two sets of early U.S. and English gun laws and said, if you look at those collectively, you can distill the principle that when someone poses a clear threat of physical violence to someone else, you can take away that person's weapons. And he said that's exactly what the domestic violence restraining order law does. And he said in particular, I think it was important to the court to look at the order that the state court entered in Rahimi's case, that the state court found that he had committed violence in the past, that there was a credible threat, that he posed a credible threat to the girlfriend and to the child, and then on the other hand, that it disarmed him for a specific period of time. It wasn't an indefinite limitation on his right to bear arms.
Thanks so much, Amy. And now we're going to talk about, for a bit, a case that is of interest to all of you, one of the most talked about cases of the term. I'm building up here to the big reveal. This would be the Loper Bright Enterprises versus Raimondo case, which overturned agency deference under the Chevron doctrine. Amy, can you quickly explain for folks who may not be familiar with the Chevron doctrine what that is?
So the Chevron doctrine, just to distill it down into just one sentence or so, is the 1984 decision that stood for the proposition that courts should generally defer to a federal administrative agency's interpretation of an ambiguous statute that it administers, as long as that interpretation is reasonable. And this is a doctrine that was, again, issued back in 1984. It was pretty uncontroversial when it was issued, and then over the years became a target for legal conservatives, both on the ground that because they were just generally opposed to government regulation, and then on the idea of separation of powers. And over the last few years, the Supreme Court had turned down several requests to reconsider the Chevron doctrine, but last year took first one case, the Loper Bright case, and then a companion case because Justice Jackson was recused from the Loper Bright case, a companion case called Relentless. They were both challenges to a rule issued by the National Marine Fisheries Service, but the Supreme Court said when it agreed to hear those cases, we're only going to take up the Chevron question. We're not going to decide anything about the National Marine Fisheries Service rule at all. We're just going to take up the Chevron question.
So in looking at the Chevron doctrine over time, had courts been applying that consistently throughout the decades that it was in existence?
So that was one of the arguments that the Chevron detractors were making, was that it had not been applied consistently, particularly when there are two steps to the Chevron doctrine. And the first one looks at whether or not Congress's intent in the statute is clear. And if the idea is that if Congress's intent is clear in the statute, then you don't need to look at the agency's interpretation and decide whether or not it's reasonable. That's just what Congress's intent is. But then in the second step of Chevron, the idea is that if the statute is ambiguous, you go on to the second step and decide whether or not the agency's interpretation is reasonable. And at that point, it doesn't matter whether the court might have another interpretation that it thinks is just as good or even better, as long as the agency's interpretation is reasonable. And so the argument was that courts were reaching different conclusions about whether or not the statute was ambiguous, and then that led to inconsistencies. And so, for example, there's one judge on the Sixth Circuit, a judge named Raymond Kethledge, who was on the short list when Justice Kennedy retired in 2018 to fill that vacancy. And he says that he has never gotten to the second part of Chevron when he's had cases reviewing agency interpretations of a statute, that for him the statute is always clear. And then on the other hand, you have cases, like there was a 2018 case involving the interpretation of a federal immigration law. And the case came to the Supreme Court because the lower courts had reached different conclusions, as cases often go to the Supreme Court when they're not the kind of blockbuster cases, involving like abortion. Often it goes to the Supreme Court because the lower courts are divided. So that means really smart people have reached different conclusions. And so in this particular case, Pereira versus Sessions, one court of appeals had said that the statute was clear. 6 courts of appeals had said that the statute was ambiguous. The Supreme Court took up the case, heard oral argument, and agreed that the statute was clear.
So the court did overturn the Chevron doctrine. I know there was speculation about whether they would clarify it or provide other less drastic measures with respect to this, but they did overturn it. What were the reasons for that decision? What was the court's rationale?
So the rationale is a little bit kind of like Bruin, in the sense that the court, and again, this is another decision by the Chief Justice, John Roberts, once again, 6-3. And if you sort of just take a step back, you look sort of at the arc of the term, so many of the major decisions this term were written by John Roberts. He was really driving the ship this term. But in this case, they looked at text and history. And so they started with the text of the Administrative Procedure Act, which is the federal law governing administrative agencies, and said that the Administrative Procedure Act, which was passed in 1946, provides that courts should decide all relevant questions of law. And the Chief Justice said, when Congress enacted this text back in 1946, it intended to codify what had been the practice, dating all the way back to Marbury versus Madison in the early 19th century, that courts should decide legal questions by applying their own judgment. And then the majority said, from the enactment of the Administrative Procedure Act in 1946 until Chevron in 1984, courts followed that same practice of reviewing interpretations generally by applying their own judgment to determine the statute's meaning rather than deferring to agency interpretations. And so the majority said Chevron was really an about face from this practice that courts had been using sort of throughout U.S. history. They said, Chevron was decided by only 6 justices, and they never really attempted in Chevron to reconcile what the majority described as the difference between this practice and the language of the Administrative Procedure Act. The Chief Justice also said, just because there are ambiguities in a statute doesn't mean that Congress intended to delegate to federal agencies the power to fill those gaps and determine what those ambiguities should mean. Again, he said Congress intended for federal courts to decide these matters, even if it involves technical and scientific questions. Technical and scientific questions may be difficult, the Chief Justice said, but this is our job, in essence, the Chief Justice said, and we have the benefit of briefing from the parties to the case, from the friends of the court who also file briefs in the case, who know a lot about the subject matter. And then talking about the doctrine of stare decisis, the idea that courts should generally not overturn their past precedent unless there are good reasons to do so. One of the things that courts look at is whether or not sort of the past decisions have become unworkable. And this was something that the Chief Justice brought up at oral argument and brought up again in his decision. He said Chevron has become unworkable. It's become impossible. Courts have had so much difficulty trying to figure out whether or not a statute is ambiguous. And then no one has relied on Chevron, which is another factor in the stare decisis analysis, because the Supreme Court was constantly tinkering with Chevron, and he said, look, even we haven't applied it ourselves in 8 years.
So in conducting its analysis, did the court put any guardrails around what agency regulations could remain in place versus what agency regulations may be opened up for judicial review going forward?
So the court said a couple of things, I think, that provide a little bit of guidance. And one of the things it said was that even if courts aren't going forward, defer to an agency's interpretation of the statutes that they administer, it can still give them respect. And in particular, the Chief Justice said, when you're talking about agency interpretations that were issued, more or less simultaneously, contemporaneously with the enactment of the statute, agency interpretations that have been consistent over time, those are the kinds of agency interpretations that are going to be especially useful. And then the other thing that the Chief Justice stressed was that overruling Chevron itself shouldn't open the floodgates to overruling other decisions that are based on Chevron. Again, sort of applying the stare decisis analysis, just because Chevron has been overruled isn't a good enough reason, the Chief Justice said, to reopen all of these past decisions applying Chevron and revisit those.
And we can't leave this case without at least mentioning briefly Justice Elena Kagan's very strongly worded dissent in this case. Can you tell us a little bit about what her thoughts were about the majority ruling?
Sure. I want to sort of address it on two planes, I guess. And the first is the big picture. And the first is that the Chevron decision was sort of the cornerstone of four different administrative law decisions, all of which went against the agency. And 3 of those decisions were 6-3. This case, a case called SEC versus Jarkizi, and a case called Corner Post versus Federal Reserve, were all 6-3, in which the liberal justices were the 3 in dissent. And the fourth one was a case called Ohio versus EPA, in which Justice Barrett joined the liberal justices, and she wrote the dissent. But, the justices read the announcements of the majority decisions from the bench, and occasionally a justice will read his or her dissents from the bench, or a summary of his or her dissent. And doing that is something that most justices only do at most once or twice per term. And doing that is really a signal of your strong disagreement with the majority's ruling. And each of the liberal justices did that in one of the administrative law decisions this term. And the administrative law decisions, especially Justice Jackson read in this case called Corner Post, involving the statute of limitations under the Administrative Procedure Act, which is not really the kind of thing you think of as sparking a really fiery dissent from the bench. But I think they wanted to illustrate collectively what they viewed as the majority sort of overstepping its role with regard to administrative law. And so Justice Kagan, one of the things that she stressed in her dissent in the Chevron case was, she called this yet another example of this court's resolve to roll back agency authority. But then with regard to the Chevron doctrine specifically, she said, Congress, for different reasons, often enacts statutes that have ambiguities and gaps. And until now, there's been a presumption that an agency's interpretation of these statutes should prevail as long as it's reasonable. And she said, in no small part, it's because agencies have the technical and scientific expertise to fill in these gaps and clarify these ambiguities. And she used a couple of examples involving, some really nitty-gritty stuff like amino acids and gray squirrels to illustrate her point. And then she sort of pushed back against, the suggestion by the Chief Justice that overruling Chevron is going to create more consistency in judicial review of agency interpretations. She said, perhaps, we may get rid of all of this arguing about whether or not, I'm paraphrasing here, about whether or not a statute is ambiguous, but now the judges are just going to be arguing about what exactly it means to give agency interpretations respect instead. And then she also sort of rejected the idea that overruling Chevron is not now going to lead to overruling other decisions that relied on Chevron. She said essentially if a court wants to come up with a special justification for purpose of the stare decisis analysis to revisit these different decisions applying Chevron, it can always do so. And so she predicted that because Chevron is so baked into the process, it's going to be what she called a massive shock to the legal system.
Okay, that was a doozy of a case.
Yeah. Yes, it was. This one's a little more straightforward.
The next case will be a little more straightforward. It is about Fifth Amendment takings law, and it is the case of DeVilliers versus Texas. Tell us about this case, which was a unanimous decision by the court, and what does it tell us about private rights of action and state sovereign immunity?
Okay, so this was a case that started because Texas wanted to be able to use a portion of the I-10 highway as an emergency evacuation route. So it put up a 3-foot-tall barrier along the highway median to make sure that the highway didn't flood. And the good news from the perspective of the state Department of Transportation is that the barrier worked, and it kept the highway open, kept the highway from flooding when Hurricane Harvey came through and a couple of tropical storms after that. The bad news for the people who had the land on the other side of the barrier was that the barrier kept the water that gathered on the other side of the dam from draining into the Gulf of Mexico the way it did before the dam was erected. And it flooded their land, ruined their crops, killed their livestock. Happened more than once, would continue to happen again as long as the barrier is there. So DeVilliers is a rancher who owns the land, some of the land that was affected. There are about 100 others who were also wound up being challengers in this case. They went to court, state court in Texas, where they argued that by putting the barrier in place and essentially using their land as a place to store the stormwater to keep it off of the highway, Texas had violated both the U.S. Constitution and the Texas Constitution by taking their land. It violated the Fifth Amendment takings clause. So Texas took the case from state court to federal court, and then once it was in federal court, argued that they should dismiss the federal claim and said, the takings clause itself doesn't give you a cause of action to go to court. You can't sue Texas. There's no federal law that gives you the right to sue Texas, and the takings clause itself doesn't give you a cause of action. The district court allowed the case to go forward. The Fifth Circuit reversed, so DeVilliers went to the Supreme Court, which agreed to take the case and then to weigh in on this question of whether or not you can bring a takings claim directly under the Fifth Amendment. In the end, the Supreme Court did not answer that question. It was, as you said, a unanimous opinion by Justice Thomas. I think it's only 7 pages. They issued the decision pretty quickly after the oral argument, at least by Supreme Court standards. They said, Justice Thomas said, our decisions don't clearly answer this question, and we're not going to answer it now because we don't have to, because the question presented rested on the assumption that DeVilliers didn't have any other way to bring his takings claim, and it's sort of a strange procedural history that Texas sort of changed its position at the oral argument. And so, we now know that DeVilliers has a cause of action for what's known as inverse condemnation under state law. And because he has a cause of action under state law, this can go forward. We don't need to decide this constitutional question, and so we're not going to.
Because I said so, right?
Exactly.
Is there anything else you'd like us to know about the de Villiers case before we turn to a completely different topic?
So this is it is, as my discussion of it suggests, a pretty narrow ruling. You know, it's 7 pages, and it's unanimous on a property rights case. Suggests it's probably a pretty narrow ruling that doesn't necessarily, it may leave as much open as it answers. So it means that de Villiers, other plaintiffs like him in Texas and other states that have a cause of action can seek compensation, but it leaves open this question of whether or not, if you don't have any other way to bring your Fifth Amendment takings claim, you can rely on the Fifth Amendment itself. So I think the answer is stay tuned, because this could be back to the Supreme Court sometime soon.
Okay, so now we're going to turn to a completely different set of cases. The court did decide a handful of cases involving various issues related to social media. So let's start with the 2 cases that came out first, Lindkey versus Freed and O'Connor-Ratcliffe versus Garnier, in which the court devised a brand new test for when a public official's use of social media accounts constitutes state action under Section 1983.
Yeah, so this was a term in which there was a lot of several decisions involving, sort of some combination of the internet and speech and government liability and coercion, and this was one of the first ones argued and the first ones decided. It was also not the first time that the justices had been asked to decide this question. Former President Donald Trump had been sued while he was in office for blocking people from his personal Twitter account, and that case did go all the way to the Supreme Court on a petition for certiorari, but the justices dismissed it in the end because by the time it made its way to him, he was no longer president. So I think that the justices were, I don't know, you can fill in the blanks, relieved, delighted to have the opportunity to answer this question in a case involving some school board members and a city manager from Port Huron, Michigan, instead of Donald Trump. They had 2 cases this term directly involving the former president already. So these cases involved, as I mentioned, public officials who blocked constituents from their personal social media accounts after the constituents made critical and or repetitive comments. And so in the Ninth Circuit, you had school board members. In the Sixth Circuit, you had the city manager of Port Huron, Michigan. The Ninth Circuit looked at whether or not there was a close connection between a close nexus between the use of social media and the school board member's official position. And so it ruled that there was state action when the school board members blocked constituents. The Sixth Circuit used a different test. It said because the city manager did not operate his personal Facebook page as part of his duties, he was not acting as a government official when he blocked city residents from his Facebook page. And then, so as you said, Susan, the Supreme Court heard oral arguments and decided it wasn't going to use either one of those tests. It really was used a test that was kind of somewhere in the middle. So the Supreme Court ruled that public officials who post on their personal social media pages about topics related to their work can only be held liable for blocking their critics if they have the power to speak on behalf of the government and they're actually exercising that power when they create the particular post that's at the center of the dispute. Justice Barrett wrote the opinion for the court in this case, and she said these decisions, I know this is not particularly helpful to all of you, these decisions are always going to be pretty fact specific. You're going to look at the content and the function of the posts. You may also want to consider, if you're a court, the nature of the technology. So for example, if it's the kind of social media platform like Twitter, where you sort of block someone from seeing all of your posts, that may factor in differently than something, a social media platform where you can block someone from seeing individual posts. So the court sent both cases back to the lower courts for them to take another look in light of this new test.
So that's not the end of the conversation on
Oh,
social
no.
media.
Yeah. We're just getting started.
We're just getting started. The court also issued decisions, or a decision in 2 additional cases that came out of, that dealt with Florida, a Florida law and a Texas law as well. And the issue in both of those cases was whether states can prohibit social media platforms from moderating user content. So Amy, can you tell us about the underlying statutes in both of those cases and how the court handled them together?
Yeah, so this is another case in which the court's ruling may have ultimately been a little bit unsatisfying, but they started out as challenges to the constitutionality of these laws in Florida and Texas. The states passed the laws in 2021 in response to a belief by the legislatures that these large social media companies like Facebook and YouTube were censoring their users, and in particular censoring their users with conservative views. And the provisions of the laws that were before the Supreme Court, just to sort of generalize that the laws were not identical, but there were sort of 2 common themes among the provisions that were before the Supreme Court. The first set of provisions limited the platform's choices about what user-generated content to present to the public and how it was presented. And then the second set of provisions required the social media platforms to provide individualized explanations about the platform's editorial decisions. So if they decide to delete or downgrade particular content, would need to provide individualized explanations about why they were doing that. So the Fifth Circuit upheld the law. The 11th Circuit, on the other hand, ruled that the law was likely unconstitutional. So everybody came to the Supreme Court seeking Supreme Court review. The Supreme Court agreed to weigh in. It heard oral argument in February, and then at the very end of its term, the justices did a little bit of punting, I think is probably the best way to describe it. They sent the case back to the lower courts for another look.
Okay. So we've talked a lot about some of the bigger cases with state impact that the court decided this term. Let's now talk a little bit about some of the cases we're going to see next term when they come back in October. Can you give us a brief rundown of what some of those most impactful cases are and what they're about?
Sure. So this is not, this past term was really, I think, no matter how you measure it, like a really impactful term. There are just a lot of blockbuster cases. And so far, the next term does not have the kind of blockbuster cases on the schedule that the last term did. But on the other hand, really only about a third of the court's schedule is set so far. I think most of the cases that were considered sort of the blockbusters from the 2023-2024 term were not on the justice's schedule at this time last year. So we don't really have a good sense of what next term's schedule is going to be like. But 2 sort of important cases that are already on the court's docket for next term. One of the biggest ones is called United States versus Skermeti, and it's a challenge to a Tennessee law that bans the use of puberty blockers and hormone therapy for transgender minors. That ban is part of a broader law that bans gender-affirming care for transgender minors. There's an exception to the law to allow puberty blockers and hormone therapy for minors in some other circumstances. So for example, if you are a minor who needs hormone therapy or puberty blockers because you started going through puberty too early, that would be allowed under the Tennessee law. So the plaintiffs in this case are 3 transgender teenagers in Tennessee who went to federal court to challenge the ban, and then the Biden administration joined the case under a law that allows the federal government to intervene in a private action alleging a violation of the right to equal protection. And so a federal judge in Tennessee temporarily barred the state from enforcing the law, but then the Sixth Circuit reversed. So the Biden administration came to the Supreme Court, which is likely going to hear oral argument in December. And the center of the argument in that case is an equal protection argument. The idea is that because Tennessee allows the use of these puberty blockers and hormone therapies for some cases, but not for the transgender teenagers, that you're treating transgender teens differently. The second case I want to mention is a case called Free Speech Coalition versus Paxton, which started out as a challenge to a Texas law that requires pornography sites to verify the age of users, pornography websites to verify the age of its users. And so the argument is that requiring this of adults violates the First Amendment because it burdens the First Amendment right to access that information, because you have to provide this personally identifying and highly sensitive information over the internet. District Court issued a preliminary injunction to block Texas from enforcing the law. The Fifth Circuit lifted the injunction, and as it comes to the Supreme Court, the dispute is about the standard of review. The Fifth Circuit applied rational basis review, the less stringent standard of review, and it said that the age verification is rationally related to the state's interest in protecting against having minors have access to pornography. The Free Speech Coalition is arguing that the proper standard of review is strict scrutiny. And then, we talked a little bit about Rahimi. At the end of the Supreme Court's term, the Supreme Court had been holding on to several cases involving the Second Amendment, sent them back to the lower courts for another look in light of Rahimi. Yesterday, the Fourth Circuit upheld Maryland's ban on assault weapons. And I know that the challengers in that case, and this is a case that came out after Rahimi, the challengers in that case have already indicated that they intend to appeal the case to the Supreme Court. So that is an issue that could be back at the Supreme Court next term.
That's a lot, you guys.
That's a lot.
Now we want to hear from you. You have your index cards. If you have questions you'd like to ask Amy about any of the cases, or even a case you didn't hear about, we'll try to answer those as well. Pass your index cards to the end of a row. I think that's easiest. And we'll collect them. And we'll go to our Q&A portion of the program. We'll give everybody just a few minutes here to think of some really good questions. Okay, and we have one already.
Okay.
Because Loper Bright is the case of the year for many of the people in this room. The question is what impact will Loper Bright have on legislative drafting, and do you have any tips for a legislative drafter?
I mean, it sounds like that my tip would be to watch Professor Merrill's live stream from earlier today. I think he covered it. It sounds like he covered the waterfront pretty carefully. But I mean, I think that it sounds like one of the things I think that you just are going to need to do is to be much clearer in your drafting, because you want the statute to say, and you want courts to interpret it exactly the way you mean for it to be interpreted. And I think the more clearly you can do that, the less likely you are to leave that up to chance.
I would agree.
The courts are the ones, so that you say what you mean and mean what you say, so that the courts are not the ones telling you what you said.
And I think also, to add on to that a little bit, the clearer you can be in drafting what exactly the role of the agency should be.
Yeah.
What do you want the agency to do? What don't you want the agency to do? I think would be helpful as well. And I know that will be a challenge in many places across the country. Here's another one. Bruin is tough on states, and legislatures and courts don't have easy access to experts on historical firearms rules. But is the alignment in Vidal versus Elster a signal that this methodology may not be used elsewhere?
Yeah, I mean, the role of history in the Second Amendment and elsewhere is really a fascinating one, because there's, I think, reasonably broad agreement, particularly among the conservative justices, on the use of history, but not necessarily on how you should use history. And I think you can see that, not only in Vidal versus Elster, but in Rahimi itself, where the justices are talking about what kinds of history counts. I mean, just as you have Justice Barrett and Rahimi suggesting that you really should look at the history surrounding the enactment, and then you have Justice Kavanaugh, I think it is, in Rahimi, suggesting that what happens after the enactment matters. And so, if you are a lawyer or a legislature drafting, it really is a question of which history matters, and I think that it's going to take a while, and it doesn't make it any easier for all of you. I think it's going to take a while to figure out exactly what history we're talking about. And it's difficult enough to do that when you're talking about modern history, but when you're talking about history from early England, it makes it even more difficult.
Okay, you can be very neutral on this next one if you'd like. What are your thoughts on President Biden's Supreme Court proposal, and could there be bipartisan support?
It is not really for me to weigh in on the sort of whether or not it's a good idea. I do think that the bipartisan support has left I think that train has left the station a long time ago. I think there was a time not that long ago when both sides were interested in that's okay, in some kind of Supreme Court reform, but I really don't think that, I think that, conservatives, Republicans are quite happy with the way that the Supreme Court is today, and they don't really see any reason to change any of it. I do think that it's always seemed kind of ironic to me that, you can change the number of justices on the court is not something that is set by the Constitution. It is something that can be changed relatively easily, whereas term limits is something that would require, I think by most people's analysis, a constitutional amendment. I don't think either of those really has any chance of happening anytime soon. Even if you had a Democratic White House, a Democratic House, and a Democratic Senate, I think it'd be very difficult to get over the, 3/4 ratification. You need 2/3 of the House and Senate, and then 3/4 of the states, and I just can't imagine that happening anytime soon. So, I really just think that I'm not sure if he was doing that as an effort to sort of rally the base to start conversations about Supreme Court reform for the future, but I can't imagine them happening anytime soon.
So this is a case, or this is a question that pertains to Fifth Amendment takings world here. Do you foresee any cases that could allow the Supreme Court to revisit a prior case of Kelo versus New London on the issue of eminent domain?
That's a great question. I haven't seen any sort of in the pipeline lately, but it was such an unpopular decision that it wouldn't surprise me if someone were to try and bring that case back to the Supreme Court with a different, given the different makeup of the court. I haven't seen anyone try to bring that case to the Supreme Court recently, though.
Fair enough.
Yeah.
We've seen a lot of strongly worded dissents among the liberal justices lately. Is there a sense of whether or not those disagreements bleed into the working relationships between the justices? Have you noticed any of that, or do you have any insight on that issue?
It's hard to say. I mean, certainly, I think, Justice Sotomayor was the one who, gave the remarks recently where she talked about going back to her chambers and sort of crying with frustration. And then Justice Kagan, in her remarks at the Ninth Circuit, she said, something along the lines of, like, I'm not really a crier so much as a wall puncher. Sort of when they are, it's so hard to know, to be honest, because we see so few of their interactions. Certainly, I think by the time they're issuing these decisions at the end of June, when they're all sort of exhausted and their nerves are frayed and they've been going back and forth, they these dissents are really strongly worded, and sometimes, the strongly worded dissents draw strong responses in the majority opinions and in the concurring opinions. And it wasn't even the end of the term, but in the Colorado ballot disqualification case, Trump versus Anderson, it wasn't a dissent as such, but an opinion, a separate opinion that the liberal justices wrote. Justice Barrett wrote her own concurring opinion in which she sort of called out the liberal justices for their tone. She said, this is not the time to amplify disagreement with stridency when you've got all of the country watching us. So, it's like on the one hand, you don't necessarily see it when they're on the bench, but on the other hand, just on an interpersonal level, it's kind of hard to imagine that it couldn't bleed over into their day-to-day operations.
So this question pertains to a case that we didn't talk about today, but it was a case that came out earlier in the last term, Alexander versus South Carolina NAACP and the redistricting issue.
Sure.
What do you think, could you speak to that case a little bit and its impact on redistricting?
Sure. So this was a case, just a little bit of background. This was a challenge to South Carolina's Congressional District 1, which is represented by Nancy Mace. And to make a long story short, the state's Republican-controlled legislature had moved black voters out of Nancy Mace's district into the neighboring district, and the voters brought a racial gerrymandering claim. And the Republican legislators countered that they were not moving the voters because of their race. They were moving them, in essence, because of their party affiliation, that they wanted to make the district a safer one for Republicans. The district had long been a Republican safe seat, and then somewhere in the sort of 2016, 2018, a Democrat had won it in a close race, and then the Republicans took it back in a close race, and they wanted to make it a safe Republican seat again. So in essence, they said it's about them being Democrats rather than them being black. And the idea that they were engaged in partisan gerrymandering rather than racial gerrymandering matters, because back in 2018, as many of you may recall, the Supreme Court in a case called Rucho versus Common Cause said that federal courts can't consider claims of partisan gerrymandering. And so it created this sort of conundrum for federal courts reviewing cases of racial gerrymandering, which is that if there's a close relationship between race and party affiliation, what do you do when you have allegations of racial gerrymandering? And the three-judge district court agreed with the challengers that the district had been racially gerrymandered. The Supreme Court reversed in a decision by Justice Alito and said, in essence, there's going to be a really high bar in cases like these, and the challengers in this case have not met that bar. You're going to have to really sort of disentangle race and politics. So it's going to create a high bar going forward. People who know more about voting rights than I do, I think that we're going to sort of see how it plays out going forward.
That's a fine answer. I think the redistricting cases, they kind of ebb and flow with the census.
The census, yes.
So we might be in a little bit of a lull here because we're hitting that mid-census mark. Let's turn back to the social media cases of Lindkey and O'Connor-Ratcliffe.
Mm-hmm.
How would you advise state legislatures, who would then advise their members, on their use of social media? Are there any clear do's and don'ts that the court provided in their opinion?
I mean, they didn't provide a lot of clear do's and don'ts. I mean, part of the test was this is very fact specific. I mean, I think probably the most obvious clear do and don't would be maybe to keep your official social media and your personal social media separate, because that makes it just much easier to figure out what's going on.
That's very practical advice. I have often dispensed that as well when I get asked that question. Just personal account, public account, don't mix them, keep them separate. Yeah. You'll be okay. To close, I think we have one final question, and it's a philosophical one. How, if at all, do you think the cases that we've talked about today have impacted respect for the Supreme Court as an institution?
I mean, I think, obviously, I think to a certain extent it depends on the person. I mean, I think different people have different views of these decisions. I mean, I think, and it's not really for me to make judgments about the court as a reporter, but I mean, I will say that the polling on the Supreme Court suggests that sort of in terms of the approval ratings, respect for the Supreme Court has been at historic lows over the past couple of terms. So, I mean, I think I can say that quite objectively.
Fair enough. If there are no more questions, which I'm seeing there aren't any, I want to thank you all for coming to our session today, and let's give Amy a big hand. And don't forget to sign up for your CLE if you need to. I believe it is still on the back table for you all.